Welcome, everyone, to another episode of Garris Horn Insights. I'm Ray Sneischovel. Today, we have Melanie Feliciano and David Ross with us. If you recall, in our last episode, we talked to David about attorney-client privilege and how that can work in a corporate environment in particular. And there were really good tips and technicalities in there. In this follow-up, I thought it would be a good idea to perhaps have some scenarios that we can play with so we can apply what we kind of talked about and learned in the last podcast and see how it really works in the real world. Because we know that it's all good in books, but at the end of the day, how attorney-client privilege is practiced in a corporate setting is really where it matters. So I thought today we can go through an example. So thank you, Melanie and David, for joining me today.
Well, thank you.
Thank you for having me.
Yeah, of course. So now a few things I want to bring up. First of all, as you know, anything we do in our podcast is not legal advice. So of course, check with your legal professional on anything when it comes to what you want to apply in your space. We're offering it here to kind of give some guidance and direction and explain things the way we see it, but it is not legal advice. Secondly, it's important to know that even that which we do talk about and seems applicable, keep in mind, and particularly with attorney-client privilege, it's jurisdictional. So the things we're going to talk about are general rules, and David, you'll talk about where you get them from, but general rules of, attorney-client privilege. States have things differently, of course, federal. So not everything here is on point. It's pretty darn close, and it's more structural. So it's still extremely helpful, but just know that we're not focusing on California law, New Jersey, or Texas. We are specifically talking in general. And then lastly, and I think this helps just so there's no confusion, when we talk about and use the word corporate, so either, for the corporation or protect attorney-client privilege for the corporation, we're really talking about the entity. It could be partnership, could be a LLC, an LLP, or something. But for our vernacular and purposes, we just use the general term corporate or corporation when explaining what we're doing here. So keep that in mind. So with that, David, anything else you want to add? Maybe explain where we're getting the rules from, I think, before we go into our discussion here.
Sure. Generally, I'm following the federal standard. Federal standard indirectly comes from Federal Rule of Evidence 501. FRE 501, though, punts it and says that attorney-client privilege will generally be governed by common law. There are some exceptions that sort of except or otherwise provided by the U.S. Constitution, federal statute, or Supreme Court prescribed rules. Generally, what we call the Upjohn standard, which we discussed last time, is a federal standard that almost all of the states have adopted. Few states have the what we call the control group standard, but that's somewhat different. So this is general, but this general information, as you said, does apply pretty broadly.
No, okay. And thank you for that. And again, you're right. We have the other podcast you can look at and listen to and see kind of the structure of where these are coming from and the technicalities of the rules, which are extremely important. But today, I want to talk about how do we apply this in a real corporate environment in given situations. Now, Melanie and I have had the pleasure of being in-house counsel for each number of years and had to live some of these things. So I'm really lucky, Melanie, that you came on board today so we can talk about this, navigate through it together, because this is not academic for us. For Melanie and I, certainly, and anyone who's been in-house, we have calluses and scars on some of this stuff sometimes. So any thoughts from you, from your experiences, and then maybe we'll jump into the examples here.
Well, I had served as in-house counsel for a mortgage technology company for about 15 years. And during that time, often questions came up in my mind as to whether or not certain communications were covered by the attorney-client privilege or not covered. And then there was a question about when do litigation holds come into play, or when do you need to start preserving communications and marking them as confidential communications subject to the attorney-client privilege. So, there are many communications between myself as in-house counsel and the executive management team. We would meet, I think it was every once a month or every 2 weeks, and discuss confidential matters that were not privy, that, other staff were not privy to. But the question also came up as to when there was a potential conflict between a partner of the company or between a customer and, my company. if a staff member, let's say a customer service rep, brought something up to me, does that then become subject to the attorney-client privilege if I thought something could lead to legal dispute? So, and I think this topic is really relevant to our firm clients, including many of David's clients who happen to be in the franchise industry. So, Dave, I'll ask a general question. For a lawyer working in-house, is all information that in-house counsel receives from executives, staff members, and other employees, and let's include independent contractors there, are they subject to the attorney-client privilege?
No, the short answer is no. Some of them could be, some of them won't be. Okay, so there are a couple of different layers here. One, the question is could this communication with this particular person be subject to attorney-client privilege? And that's where we get into the Upjohn test, right? So the Upjohn test says, for example, this is the type of communication that would be subject to attorney-client privilege. Communication with somebody who's higher level, who is trying to get legal advice, is one thing, and it's easier to determine. Attorney-client privilege is a tougher call, maybe with a low-level employee, right? And the question really is whether this person was directed to communicate with the attorney for the purpose of helping the corporation get legal advice. And at that stage, once that has been determined, that conversation has to be limited to what is necessary to obtain the legal advice and limited to what the employee needs to know. So, for example, you have a low level, we talked about, I think, a security guard last time who saw something happen. The communication about what actually happened, if this is the only source of the information or the only legitimate source of the information inside the corporation, would be privileged to the extent you're discussing that issue, right? To the extent that as the in-house counsel, want to spout off, well, you see, perhaps this is a violation of this or a violation of that, or maybe we should consider doing X, Y, and Z that's really outside of the scope of what that person needs to know, then might not be might not be covered by the privilege. So that's the first part. The second part is sort of overlaps in that it's subject matter. And it's subject matter as to what does this person need to know, but it also goes back to legal advice. So as an in-house, you might have business roles, you might have business responsibilities, things that are not so law specific, legal specific. So in that particular case, the question is whether really the bulk, usually it'll be about whether the majority of what is sought through the communication is legal as opposed to business.
So in Melanie's example, if you spoke to, I think you said customer service representative on something, and maybe it was just, you kind of know them, you're in the coffee room, you're just talking about, an issue with a counterparty, which eventually will be a counterparty, right? In some sense. So it's another client or a vendor or something to that effect. And then he randomly mentions that, oh yeah, this is what happened. And, really we kind of screwed up and we did something, whatever it is, something you might want protected under privilege. That might not be the time and place to that it would be protected per se, because it wasn't the intent. Depending, and again, it all depends. I know, David, but I'm just trying to set the stage, if you will.
Yeah, what Upjohn and its progeny make clear is that there's not a bright line test; it's fact specific. But what Upjohn also establishes is that the privilege isn't what we call self-executing. You need to do a little hocus pocus before it applies. So if I'm talking to an employee that I spoke to had to have been directed to communicate with me, for example, by a superior, and it had to have been for purposes of getting the legal advice, I have to give the warning. I represent the company. I don't represent you. Okay. So I need to also confirm this person has information that's not generally available elsewhere, and that this is information that I need in order to advise the corporate client.
So like in that, I'm sorry, go ahead, Melanie.
Well, I was going to say, so is the threshold question here, who is your client? And in this case, of course, it's the entity, the corporation, the LLC, what
Right.
have you. But who represents the client? And you're right, I think, it would be the CEO who may be seeking legal advice from you, a founder of the company, the president. Would you say maybe someone on the executive management team, if they are seeking legal advice? But I think maybe it's not the entire executive management team. It just depends.
It depends on who's been authorized. So, Model Rule of Professional Conduct 1.13a, organization as client. When I say model, this is the ABA model.
Mm-hmm.
It says, quote, a lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. So the question is, who is authorized to speak with you? So there are people that might be authorized to speak with the in-house counsel generally. There might be people who were specifically authorized. Maybe we're talking about maybe it's a parent because of the level that they're at. Maybe they're lower level and they specifically said, I was asked to speak to you because I was directed by blah, 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 blah. Okay.
So
Okay.
following up on that, is it critically important to have like a board resolution authorizing certain individuals within the corporation who can seek legal advice on behalf of the corporation from in-house counsel?
It might be it might not be a bad idea, whether it's resolution or whether it's some other sort of corporate document. This is who can communicate. If you're a small, closely held organization, it might be a little bit more loosey goosey.
Mm.
And it's just like I always tell clients, you can get three different judges with three different opinions on something,
Mm-hmm.
but to the extent that you can cover yourselves, it never hurts to do
So,
so.
let me ask this then. So, going to your point, Melanie, if you're going to have some kind of a corporate resolution or similar document, I suppose we wouldn't want to pin it too tight either. Only these people can seek legal advice on behalf of the company, because if you actually do find yourself in a situation that maybe we could defend and it was real and it was a security guard who ran up to you and said, "This is what happened immediately." Well, he wasn't on the list, so it doesn't count. I think we have to be strategic on that. But your point's well taken. I'm not trying to take away from that. I think that's an interesting point.
Yeah, but I would tell that security guard, don't run up to me. Don't talk to me because you have to have been authorized to speak to me by a superior. This has to be within the scope of your duties, right? Security guard says, I saw something else. Now, let's just say hypothetically, security guard saw someone sexually harassing someone else. And let's just say it's not quite within the scope of this person's duties because this person's guarding the door. Saw what was happening when a couple of officers were were speaking with one another. It might be a little bit different. I might say, well, this is something to speak to HR about, right? And then maybe at that point we determine how to go after that.
Got it. So
But
let me
I would never have somebody go run up to me unless someone who is authorized, someone who would be under the old standard, part of the control group. These are the people that would speak with me.
and I think that's a fair point. I think in reality, like Melanie can probably attest to this. That's why I said sometimes we're in a lunchroom, they know you're the lawyer, and it slips up before you can even know what's going on. So they virtually run up to you and you can't stop them. So what I'm hearing is, don't assume that every time you meet someone and there could be something that is of legal conversation and maybe and certainly worthy of attorney-client privilege, it doesn't automatically attach. Facts and circumstances matter.
Right.
Getting it from a leadership role for someone in leadership is more likely to be able to authorize on behalf of the company. Remember who the client is. So we can put fact patterns galore about this customer service messed up and lied on his own account that put the company at risk, but him also, right? So it's like, well, so we got to find who we represent, and you default for me is always the company. But let me ask you this. let me adjust because I'm talking real world stuff. I understand where you're going with it, David. But Melanie and I will tell you that coffee room, boy, it's like, oh, you told us, like, okay, I wish I wouldn't have heard it. Now we're in this context sometimes. But let me give you an example, because this is what happens too. So, Melanie, you talked about executives and CEO of the company, whichever, and we kind of talked about it in the last one. I think I kind of know the answer, but I want to reiterate here. We will get emails from them, right? So you get the executives and maybe the sales manager, and there's some kind of issue with the complaining borrower or whatever that might escalate to an issue, and that's what they think. So they send each other emails, and they CC me as the attorney, keeping in mind I'm not even aware of this until I get CC'd. Is that communication, let me put it this way, is it more likely or less likely that's protected by attorney-client privilege, just on the facts I've given you?
It's one of those it depends answers, unfortunately. It
Of
depends on the
course.
contents. But I'll say this. You, just like we were saying before, you don't create attorney-client privilege just by calling it that and sending it to the attorney. You don't take a fact that otherwise would have been privileged and thereby, or otherwise would not have been privileged, I should say, and thereby make it privileged because you communicated to me. So let's just say Joe tells me he shot the janitor. Well, sorry, it's not like the fact that he shot the janitor is now something that no one can discover, or the communication that you and Joe had that he did that. Really, it's not the underlying thing that is being protected. It's not the underlying fact. It's not the underlying subject matter. It's the communication with the in-house attorney.
Mhm.
So it's not like the general substance is off limits because it's been communicated to the attorney. It's no, what did you say to the attorney? What did the attorney say to you? And the big test again is whether the majority of this was generally a communication made for purposes of obtaining legal advice. So Joe tells me he shot the janitor. What the heck do we do? Right? Okay. Well, question. Maybe Joe shouldn't have been copied on this. That creates a different issue here,
Right.
right? Because sometimes if you have somebody who was not supposed to be on there, you might have ended up waiving the privilege. So that you got to be careful. So Joe tells me he shot the janitor. What do we do? The fact that you asked me and the fact that I gave you an answer, what I think we should do, all that stuff, that communication back and forth is protected, not the underlying thing, and not the communication between the two of you. It's not like, hey, let's just make everything privileged by putting the CC line.
Very
That
good.
won't work that way.
So putting it another way, I would submit that they're, again, all facts and circumstances, everything being equal. Submit, and I see what you're saying. If they communicate to you, meaning I'm the lawyer, the in-house lawyer, and it's the CEO, and let's say it's just an email between the two of you, and he says, I heard of a situation. I'm the CEO. And the implication is I'm the CEO. I'm authorized to talk about legal issues on behalf of the company. Something happened. Joe shot the janitor. What do we do? Even though the attorney there didn't initiate, there's a chance that it could be attorney-client privilege, even though it's initiated by the CEO. Is that a correct statement?
Yes.
Got it.
Now,
Okay. Yeah.
now they say, hey, he shot the janitor. What does this mean what will this mean for our shareholders?
Right.
What will this mean for everything else? Like, that wasn't really legal advice you were seeking from me.
Right. Okay. So now flip it a bit. If we have an email that's initiated, so the whole thing is initiated by the attorney, so hey, we just got served, and so I'm going to email the right people, the CEO and the president of the company. I'm the general counsel. I'm emailing you and saying, just letting you know we got sued. Don't talk to anybody. We're looking into this, so on and so forth. There might be issues here. There might be a response from the CEO or the president in that regard, like, yeah, I'm familiar with that issue or whatever. Because there's probably a stronger sense that it's attorney-client privilege because it was set up by the attorney to begin with. Is that a fair statement?
It's a fair statement more because of the subject matter. But if I send it out, it's who am I giving it to? If I send it company wide, that
Sorry,
doesn't necessarily right.
My example
I'm
is the
sorry,
CEO
go
and the
ahead.
president. Yeah.
It's the CEO and the president. Yeah, probably.
Yeah.
And I will, as a litigator, I will take, it's my client, I'll take an expansive view. I'd rather be safe than sorry in terms of what I'm going to argue is attorney-client privilege. Right? So Yeah, and that communication, here it is, what do we do? I would argue, and I believe, it's attorney-client privilege. Which is funny because I was in court recently and I made a point about something and the judge started arguing with me about it. And I politely said, Your Honor, I understand that my view isn't what's going to govern here, it's the court's view. But the court asked me a question and I gave the answer as to what I believe. And that's what we do in a lot of circumstances. We make judgment calls. And the best thing we can do is to just be as careful as we possibly can so that when arguments come up, we're as protected as possible.
Okay.
So what if you're in-house counsel for a closely held corporation? The corporation is served with a lawsuit and the general counsel provides instructions to the entire staff. You know, if you get a call from this person, don't answer it. Don't engage them in conversation about this particular matter. Refrain from certain things. Are those directives from general counsel to like a certain department or staff in general? Would that be subject to the attorney-client privilege?
I would think.
Okay.
I would think it is because this is their role. This relates to this. If I'm authorized to speak with them and I'm authorized to direct them, then that's what I'll do, and that's what I would argue, and I think I would probably argue that successfully.
Okay.
So when, sometimes either an executive like the president or CEO, or even I as the general counsel may mark an email communication as confidential, attorney-client privileged. By doing that, does that automatically make that communication subject to the privilege?
No, it's again, you go back to the substance of it and you
Okay.
go back to the circumstances. It's if there was a magic way to create attorney-client privilege, we'd all be doing it all the time. We'd put it on everything. Now, sometimes I would say there might be circumstances in which there's a use. There's a use, number one, as the in-house counsel or the outside counsel, I'm sending it and giving somebody a directive not to share it.
Mm-hmm.
This is attorney, because if you share it with someone who's not authorized to see it, you can waive the attorney-client privilege that does exist. There might be a question, as I mentioned before, about whether we're talking legal advice or we're talking business advice. And
Right.
if it is really on the edge, perhaps we could convince the judge that, well, the purpose was to obtain the legal advice. It looks like it might be a close call, but that's certainly what we were thinking. We certainly weren't thinking of talking to the in-house in her capacity as an executive vice president.
Okay, so what I'm hearing, let's flip it on the other side. It's a great point, Melanie. So let's flip on the other side. The fact that I didn't tag something attorney-client privilege, but we can show all the factors are otherwise met for attorney-client privilege. We didn't waive it simply because we didn't tag it attorney-client privilege, correct?
That's correct.
Yeah, okay.
The question is what's in there.
Right.
And the question really is the substance. Now, the fact that the attorney doesn't label it attorney-client privilege, it has even less meaning because the privilege doesn't belong to the attorney. The privilege belongs to the client.
It's true.
It's the client, which is the corporation, that can waive it. Now, if I have a communication as the in-house with somebody who was not authorized to have it, it wasn't even a matter of waiving it. It was a matter of not having an attorney-client privilege communication to begin with.
Okay.
Okay.
You made an interesting point earlier, distinguishing between legal advice that a general counsel may be giving its client versus business advice or other kinds of advice or recommendations. I know that there are situations where in-house counsel could be crossing a fine line where they may become a witness to, a certain case. And so do you have any recommendations on how in-house counsel can maybe prevent themselves from ultimately becoming a witness in a case and being able to just preserve that attorney-client privilege with their client?
Well, the in-house counsel, as pure in-house counsel, might have two separate roles. One is providing internal legal advice, and the other might be communicating with third parties. Sending a letter, we are going to sue you if you don't do this. Communicating with somebody regarding that. If your in-house counsel is doing that, your in-house counsel very well might be a witness with regard to what he or she is doing vis-a-vis the third parties. So it's really the internal communications. Now, if the internal communications are a mix of business and legal, perhaps one way to do it, and again, this isn't uniform, but generally the courts, from my understanding, will say, hey, was this communication more legal than business? If it was more legal than business, even if there was a lot of business in this communication, then generally we're going to say it's attorney-client privilege. There might be a way of just saying, well, to the extent we're having written communications, either don't have me communicate so much on the business end, or don't have me, or if I am going to do it, just I'm going to have to make sure that I have more legal than business. There's also the question of best evidence. It's not always necessary to bring an attorney in as a witness. If this was a communication between the attorney and the CEO, perhaps the CEO will suffice as a witness. Perhaps. I mean, that's really a bigger issue, really, when we're talking about someone, usually an outside counsel, although some in-house counsel will sometimes conduct arbitrations, do things like that. But I've been in situations where we're saying, well, I want to disqualify this attorney. I want the court or the arbitrator to disqualify this attorney because this attorney, was an integral witness. This person was involved in certain things. And sometimes in that circumstance, the issue will be whether there's any other way to get the evidence.
I once heard a situation where the in-house counsel in deposition asserted attorney-client privilege, and then when they wanted to put them as a witness, because it was favorable to the counterparty, put him as a witness in trial, there was an objection. It's like, no, we couldn't depose him. So what he's saying, so you can't be both a witness and protect everything in attorney-client privilege. That was the underlying premise. So, and again, I don't want to get too technical here, but it tells you how it can get muddled quickly when you do want them to be a witness, but you don't want them to be deposed. So how do you, that kind of situation?
Yeah, I mean, if our position is you can't ask a single question because everything is protected by privilege, then that's a problem. But if you're asking the question, what did you two talk about internally? We could say that's privilege, but what you did outside, the fact that you did something vis-a-vis these third parties or took these other actions out in the world, that's not protected.
Mm-hmm.
Yeah, understood. And I think in this case, they asserted it was, and there was no objection to it in deposition, and you can rely on court. These are jurisdictional things.
Yeah.
I'm sure it's local rules. So don't say it's going to apply everywhere. But it was interesting because when the attorney, in-house counsel, wanted to testify and they were the counterparty, of course, they were adverse. And they wanted to testify on behalf of the company being sued. They said, no, you cannot, because you said it was attorney-client privilege. So you can't do it in court. You can't have it both ways. You can't be a witness in court and be attorney-client privilege in deposition. And so that apparently in that instance was upheld. I don't know the rules on it. I can't say it happens all the time. But you bring up a good point, Melanie. Careful what you ask for. You just might get it either way.
Right.
Now, question I'd like to talk about. Is shifting the conversation to work product. So we talk about attorney-client privilege. I want to say is broader, but factually could be broader. I think we have a situation, etc. Correct me if I'm wrong. Work product is really where you truly have either litigation or close to or great anticipation of litigation. The distinction and does that make a difference insofar as how we produce it, how we label it with work product versus attorney-client privilege?
Sure. And it doesn't necessarily have to be great anticipation, but it has to be anticipation. I created it because I think this might turn into litigation, right? Or maybe there actually is existing litigation. I'm doing that. Unlike attorney-client, attorney work product privilege belongs to the attorney. And it's also not absolute. There are circumstances in which it doesn't matter. It can be used, or some exceptions. For example, when there is no other way that the other side can get certain information, trial they can maybe go into the trial prep. But yeah, so that's what this is. But generally, it's the attorney who can waive it, and it is something could be attorney-client privilege and work product.
Mm-hmm.
I could create a chart for purposes of going over everything with the client, and it's both privilege for purposes of the communication and work product because I created this. This is my job, and I'm trying to get this thing done. They are treated a little bit differently. Here's the thing about work product. Work product it's really hard to inquire as to what the work product was, what I was doing, whether it was anticipation. Sometimes it is just murky enough. And I haven't really had that experience in my years of practice where somebody was fighting over whether something was work product or not. That usually hasn't been an issue. Now, as you were talking before, if you want to label it work product, that might help. But just like we were saying with attorney-client privilege, it doesn't necessarily govern. Not everything I do is going to be attorney work product. But if there's a question of what we were intending, what we were doing, yeah, that might be a factual scenario, unless we're labeling everything under the sun work product. I would say it's fact specific as to what was really intended and what was being done at that point.
Okay.
So as I've been listening to your responses, David, in my mind, I was trying to come up with best practices that the general counsel or a chief legal officer could adopt to ensure that truly confidential communications become subject to the attorney-client privilege. And now what I've been able to glean from you so far is that it would not be a bad idea to have policy or or corporate resolution, board resolution adopted stating which persons within the organization are authorized to speak to in-house counsel to obtain legal advice on behalf of the company.
Sure.
And when such communications are deemed to be confidential and not, maybe training your executive management team. Like I can see, maybe each department head is going to have authorization to speak to in-house counsel about legal issues they think have arisen and to seek in-house counsel's advice on how to proceed on a particular matter. I'm thinking that those two things just establish who is authorized to seek legal advice on behalf of the corporation from an in-house counsel. Maybe it may be good to do that and to have, periodic training of those persons as well as in-house counsel so that, like legal staff can discern what is attorney-client privileged or not, like two separate trainings there.
Right. If you're going to authorize, I would, number one, I think I would just personally would be a little reluctant to empower too many people.
Right.
Because you're speaking on behalf of the organization. And the more dispersed it is, there's a question of whether you're really trying to get this on behalf of the organization. If you're a department head, the issue really should be you're going to take it back to superiors. You're going to share this, and this is within my responsibilities as a department head. If you're talking about plant operations, if you're talking about what's, physical operations, you want to have the person dealing with physical operations maybe being the authorized person. Don't have somebody else if it's outside the scope of their duties. That could create other problems. And I wouldn't say, well, if it's factual, there's a difference between authorized to communicate in terms of getting the legal advice. What do we do? How do we do it? And on the one hand, and just providing information on the other. And I would be careful going too low down the food chain,
right,
on that, because is it really part of their duty to try to get the advice? I'd be careful.
So Melanie, I think it's a good point. It's advising the company as to how best, and nothing's perfect or always, right?
Right.
but best that we can preserve attorney-client privilege and here are the rules of the game. And going to David's kind of direction, it's don't make it too broad. I'd be cautious to make it too tight as a matter of rule, because you might have to have someone who's otherwise qualified in given the situation and quote, they weren't authorized, and that becomes an issue. I think you could probably still defend it anyway, but the point is that we put the box too tight. But here's my question, David, and Melanie, you probably have experienced this too. Then what's the direction you have somebody in production? Let's say it's loan production in our context, right? That I'm familiar with. It's loan production. They recognize there's something wrong with the system and it's calculating APRs incorrectly, whatever, right? Of course, they are a supervisor. How do they escalate that in a manner to counsel that all those communications are protected under attorney-client privilege? Is it they talk to the supervisor and the supervisor say nothing more, then we get the lawyer involved? I mean, how does that happen actually?
Yeah, I mean, you could, just like when we were going through the Upjohn stages, there's the issue of authorized by a superior. So I think probably best practice, if this is a very specific type of fact, is to go to your superior and say, hey, please direct me to go to in-house counsel. Can you direct me to do it? And then we'll have this communication of what this issue is, because I want to help you, superior, get the best legal advice possible, or to ensure that I'm doing something that complies with what the company is supposed to be doing.
And so, okay, so that's probably the best. I mean, again, in perfect world, you can do that. I'm not sure always in perfect world, but that's as tight as you can keep it. Communication, escalate it without getting too detailed and involving too many people, especially, and what I'm hearing, Dave, especially people who shouldn't be involved. So it's harder to prove when it's like, oh, we also had extra people in the room that I told. It's like, that wasn't a good idea. So
right. You keep it limited. Maybe one of the ways to do it is say, hey, in this situation, you are authorized to, you have this authorization, or authorized by superiors generally when this situation comes up, to ask the in-house counsel. And the in-house counsel is going to keep it very narrow as to what's going on, and they're going to keep me apprised.
Good.
Or keep us up top apprised. That might be the best way to do it, instead of doing it on a per item basis. Something along the lines of what you were saying, Melanie, is that maybe what we do is say, yeah, in this situation, you are authorized to speak with this person, but these are the things you need to do. These are the things you can't do when doing
What I
that.
would do is when, let's say, a customer service representative or someone in the technical team brought a potential legal issue to my attention, I would gather the facts. I wouldn't give them any advice, but I would report it to my boss, the president and CEO, and report the facts that I had heard and, offer my business and also legal recommendations in terms of how to treat those facts. And if, my boss would authorize me to speak to other executives about how to treat that particular issue, then I would do that.
That's a good way to do it. That's a good practice.
Okay, then let me ask you, we were talking about pretty much in-house counsel, because that's really a key point here, in the company and what works and what doesn't. I want to switch it up a little bit and see what you think. How does the dynamic, and again, we could talk to hours on this one, I'm sure, but generally speaking, how does the dynamic change when we are engaging outside counsel for a specific matter and purpose? I think I know the answer to some of it and connect the dots, et cetera, but what are your thoughts there when we bring in outside counsel to handle an issue?
It might be easier.
Yeah.
Because unless the outside counsel is outside general counsel, who advises them on all sorts of things, it might be clear this person was retained to deal with this specific legal problem, this thing that arose. If it's a litigator, I think it's clearer that what we're communicating is attorney-client. And what I'm doing, if it's litigation related or in anticipation, that it really is work product if I'm the outside counsel. I do think that there are certain things that we can do. I think we might have touched on this in the first session that we had. I could say, look, as the outside counsel, what I want you to do is gather information. We talk about when we should say attorney-client privilege. This is when we should really say attorney-client privilege on the top of things and make it absolutely clear. I say, I want somebody to investigate inside, okay, for purposes of explaining it to me, enabling me to give you this legal advice or to represent you. So if the idea is, these are the questions I have, and I want you to ask these people, I want you to get me the answers. If you label that accordingly and make it clear as the person inside, it could be the same thing with in-house counsel, actually. So-and-so, the in-house counsel, wants this information, wants to gather this information for this purpose. I would be pretty explicit as to what the purpose is, and the fact that purpose is to help us communicate with an attorney, and that this person wants this information, we're getting this information. We had that with a client recently. We're saying, we want you to do this stuff. Again, you're not going to protect the underlying information, but maybe these emails that are communicated, or these notes that are taken, these things that are done for purposes of communicating with the outside counsel or with the general counsel who's investigating, that could end up being protected.
Okay. Well, Melanie, any other questions as we close this up? Any other ideas, thoughts? I mean, I have been, like I said, I've done this general counseling a lot. I do know, as a matter of fact, it's not always easy to control the dialogue dynamics, who we talk to, what they say in a corporate world. And this is my experience. And at the same time, I submit, just because you heard something here, like, oh, we did that wrong, it's like, therefore you blow it at, as there might be a way still to preserve it. The rules might be different in your location, in your jurisdiction. So, if you're in a situation already and you heard something here, like, jeepers, we didn't do it correctly, just go to counsel, find out if you did it correctly or not, so don't necessarily concede that it's wrong. There's so many moving parts. But I will tell you, as a practical matter, you've got a great visual, David, with someone runs up to you and says something. That's literally how it happens in a corporate environment. And I haven't been in it a long time. And we try to control as best we can for that. And I think we have. I know in my experience, we have done that successfully. Yes, we use outside counsel. I made sure that outside counsel was in charge of the direction of everything that we did, to make sure who said what and who was directing it. They would direct us to check with this, talk to so-and-so, so on and so forth. So it's nice when you have outside counsel, but I will tell you that's not always the case. So I don't want to get people to be discouraged about how intricate it could be to maintain privilege, but do your best that you can, and then we'll work it from there, is what I'm hearing.
Yeah, absolutely.
Yeah. Okay. Melanie, I'm sorry, I jumped on you. Any?
No, you didn't at all.
Yeah.
I mean, I think, David, you covered everything that I had questions about. So thank you very much for your expertise and the general advice.
Yep.
All right. Thank you.
David. So again, the takeaway, that privilege is not necessarily simple or easy. There are some rules behind it. Includes people who's in the room, right? So even simple things, as we talked about before, you can accidentally waive it and didn't know it. That's what we talked about last time. And now we have some kind of direction in situational cases, how to respond and best respond in certain cases. I think that works. So thank you, David. Thank you, Melanie, for your time. Thank you, everyone, for listening to this episode of Garris Horn Insights, and I look forward to seeing you at the next episode of Garris Horn Insights. Thank you. Thank you, everyone.
Thank you.
Thank you.